in your reach, Your Honor. Your Honor, we had done a very comprehensive letter to the DPP earlier today, just for the information, and I think it's only fair that within the 4 weeks that were being sought, those grievances can be addressed in our letter. And I think the prosecutor will have an opportunity to liaise with his seniors, and he may be compelled to terminate these proceedings altogether. If they so desire to come back on the 14th day, we undertake to avail our clients as and when it is required. We humbly pray, Your Honor.
Your Honor, there was a second charge sheet that has just been brought to our attention. The one that now involves Ms. Takibe.
See the file? This is the file that we were dealing with, the one that we are dealing with, and the current file. Yes, the one we are handling is 836 of 2024 for Jimmy Wanjigi and David Chibe.
Yes, Doctor.
It's the one that we are handling at the moment.
Yes. It goes together with the number of the other one.
There is one which we've not read,
Yes.
837.
That's where the firearm certificates are. So I just felt that I bring out the issues so that, because they are all related.
What did you want us to do?
I just want to raise them, Your Honor, because we can use the same proceedings.
Mm-hmm. We can use the same you'd want to adopt the proceedings in this other matter.
Yes. And I was going to only urge, Your Honor, that in this particular one, this is where Justice Bahati's orders emanate. And this file and the charges therein are the subject of proceedings in petition E396 of 2024.
It is the subject of proceedings.
In E396 of 2024. And amongst the issues raised in that petition is what, in my short, I came to experience firsthand. I used to watch it in movies. Raiding of a home by over 500 police officers. Majority of them wearing balaclavas and carrying assault rifles, high caliber assault rifles. And a comprehensive search of the entire compound and every single room in the home conducted by the police in the presence of family, in the presence of lawyers. That comprehensive search runs from 7 p.m. to 5 a.m. in the morning.
A search from what time?
7 p.m. on the 8th of August to 5 a.m. in the morning on the 9th of August. And the only items discovered and confiscated by the police, which is inventorized and signed by all the parties, are the following: iPhones belonging to Jimmy Wanjigi's family members, wife, children, mother. iPads, 3 flags, lapels, a fuel receipt for Total Energies Muthaiga. Those are the items that were deemed to be of interest to the state only. Then at 6 a.m. after that search is concluded, inventorized, recorded, and closed, the home closed. Another set of over 200 armed men wearing balaclavas turn into robbers and break into the home. And all that this group does, they rob the workers, the staff of the home. They rob the grieving widow, Jimmy's mother, of money in her wallet. She's forced to open her wallet. They steal her watch. They rob Jimmy's children. They steal household effects. But if that is not enough, poor Willis Otieno, his lawyer, my motor vehicle KCL 341F is equally targeted, and they steal my wallet. As I stand here, I only thank technology to prove that I'm an advocate. Amongst the items stolen is my LSK membership card, my debit cards, US dollars, and Kenya shillings in 1,000 notes and in 100 notes. US dollars in 100 notes denominations. What did I do? Just to be a lawyer for Jimmy Wanjigi's family. But today we are told that group of robbers purportedly discovered explosives in Jimmy's home after doing the robbery. And they want to present a charge. That is the subject of E396 of 2014 petition before the High Court. No inventory, no presence of family members, no lawyers, as they are done for over 10 hours. And as they are doing all of this, they don't have any order. No order. No order at all. No search warrant that they present to be there. That's why I refer to them as a bunch of robbers. All they did was to rob, and to cover their theft, they want to present a charge here before court. In disobedience of the court orders that told them not even to arrest, not even to detain. It's the mythical story of a thief who runs on the streets and starts shouting, "Thief, thief, thief," to send you the wrong way. These are questions that are alive and active in petition 396. Compelling reason to defer plea. Let's deal with that question in that petition. And Justice Bahati saw it fit and reasonable when he looked at the substance and he said, "Don't arrest Mr. Wanjigi. I want to look at these things. When the petition comes for hearing, they are parties, all of them. They can tell their story before that court. The final point, Your Honor, is even when you will retire to consider these submissions, there is this live question that is before you. Orders issued by Justice Bahati saying Mr. Jimmy Wanjigi should not be arrested. And if he is arrested, he should be released forthwith. He is before you as an arrestee being held by Mr. Sang, a contemner. He was held overnight at Kamukunji police station. And he was held incommunicado, with no access to his lawyers. This court should assert, even as it considers this submission, that Mr. Wanjigi is a free man by that order. And for us to submit to the authority of the courts, we must all accept that Mr. Jimmy Wanjigi is a free man. He cannot be arrested or detained by the state until Justice Bahati or another judge says so. So we respect that as a bare minimum. He should not be here as an arrestee of Mr. Sang, a contemner, who has not purged this act of contempt. And nobody is challenging Justice Bahati's orders. I'm only asking the court to say it for to their hearing. The orders already exist. We are not even asking for any fresh orders in that regard. Just tell them, for those who are slow of hearing, let them hear it, that the High Court order applies to them. And they have their lawyer, the prosecutor in court. Can tell them, please respect these orders if you want audience and participation in this proceeding. Madam Asha wanted to.
Thank you, Your Honor. I wish to fully associate myself with the submissions of my seniors, and just to reiterate to this honorable court that Jimmy Wanjigi has had these cases before him. My senior Willis has illustrated, but the reason we are here, and I'm sure we want to ask each other, is why in the first place we are here. Court orders are not meant to be dished out just to make people happy. The court is a place where each Kenyan and any Kenyan can go to seek for justice. What are we telling the courts, and what are we telling Kenyans? That you can go to one arm of government and you're issued orders, but the orders will not be respected. This issue started when the home was raided. I was personally there. I was shocked by the contingent that was deployed there. And making matters worse, there was no orders, no search warrant or anything. But we complied. As law-abiding citizens, the search was done conclusively. As my senior has said, at 5, 6 in the morning, they're back. But what is interesting is that they come, first of all, to destroy, disconnect electricity and Wi-Fi. If you're doing the right thing, why would you go to such lengths? It is prudent to say that we should not be here today because the court of law, just like today they've presented the two accused persons before this honorable court, how they want their orders and their way to take place. However, they cannot respect orders from another court. The issue of firearms has been addressed prior. It's not something new. So, Your Honor, today we are humbly requesting that the judiciary, through your office, sets a precedent that one arm of government cannot be seen not to respect the rule of law. The 2010 Constitution, we fought for it. We enjoy the rights envisioned here, and justice should not be selective. Inasmuch as we want to respect the rule of law, it goes down to respect court orders. As a judicial officer and as a Kenyan, I humbly request, just like my seniors have said, that this issue be deferred by virtue that their court has already made pronouncements prior. We cannot be doing the same issue every day. So I humbly request this honorable court to take that into cognizance, to look at the manner in which even the second accused person was beaten up, and his only crime was to be his aide. As we speak, I also request that he be allowed to get medical treatment because he's in pain. So I humbly request this court to set a precedence that the court is there to give orders, and the orders should be respected. And if a party is not happy, there are modalities to transverse the same. Thank you, Your Honor.
Your Honor, before the DPP response...
Senior counsel, with all due respect, it seems we're not...
No. I'm not making any submission.
Okay.
I'm just saying inadvertently, I failed to mention to this honorable court that part of the defense team also consists of the Honorable Dan Maanzo, who is present in court. I should have included his name. And also Nelson Harvey, the immediate past president of the Law Society. I thank you.
I'm present, Your Honor. I had to come out of retirement to come and confront this tyrant.
I think they are through.
Yes.
I'm not sure if any of my colleagues would want to.
You have anything you wish to say? Just remind me the name.
My name is Wanjigi. I am here on the instructions of the Director of Public Prosecution. And also my colleagues who are in the quorum. I'll start from my learned colleague, Mr. Mwenda's submission that the prosecution probably need some time to be able to respond to the application this morning. We are grateful for the offer, but I am ready to go right now. Number two, I want to be sure that I understood the nature of the application. And the prayers that we have heard the defense ask for are, number one, that you defer the charges, and or number two, that you reject the charges, and or number three, that you stay the charges, and or number four, that you throw those charges into a dustbin. And Your Honor, the reasons for those prayers, Your Honor, I've noticed the court is not writing.
Yes.
May we know why?
Don't worry about that. I've heard you. You've just reiterated what they say.
Okay,
Yes.
That's good enough. That's good enough. The reasons that the defense has given, number one, is that the deferment of charges should give the defense an opportunity to go back before the Honorable Bahati Mwamuye to seek contempt orders as against the respondents in petition E396 of 2024. That's ground number one.
To go back to Justice
Bahati Mwamuye to institute contempt proceedings as against the respondents in petition E396 of 2024. Number two is that the respondents have violated the rights of the intended accused persons. Number three is that the respondents have violated a number of provisions of the Constitution of Kenya 2010. And number four, before I get to the final number 5, number 4 is that the charges are bad because they are defective. And finally, number 5, for compassionate reasons because the first accused person just lost his father. On the basis of those grounds, Learned Senior Counsel Dr. Haminwa has asked you, 1, to be courageous, and number 2, to make history by rejecting the charges. Now, Your Honor, that's our understanding of the dispute from the defense side, the basis for which they want either rejection or a deferment or a throwing into the bin of the charges before you. However, any court, including this court, can only do what it is empowered to do. And my starting point is the jurisdiction of this court. This court can be courageous, can be bold, but only within its jurisdiction. The criminal jurisdiction of this court is provided for under Section 6 of the Magistrates Courts Act 2015. Sorry, Your Honor, just before I go to that, it's trite law that jurisdiction is everything. I need not quote the authorities, but one of those is Samuel Kamau Macharia versus Kenya Commercial Bank and another. And of course, the time-tested owners of motor vessel S. On the basis of those two authorities, the criminal jurisdiction of this court is provided for under Section 6 of the Magistrates Courts Act 2015. But there's also an important aspect of your jurisdiction under that act, provided for under Section 8 of the Magistrates Courts Act 2015. And that jurisdiction is the jurisdiction to enforce constitutional rights and fundamental freedoms. Your Honor, Section 6 of the Criminal Procedure Code gives you powers to hear and determine criminal charges as the intended ones on the basis of the subject charge or charge sheet as delineated by the Criminal Procedure Code, as the CPC, or any other written law, including the Penal Code. Or any other written law, including the statute, the basis of the charges before you in both the charge sheets. The court will have an opportunity to have a look. So that is Section 6. Now let's go to Section 8 of the Magistrates Courts Act, that this court has powers to enforce rights and fundamental freedoms limited to Article 25A and B of the Constitution. Article 25A and B only of the Constitution. You know, the first concession we make at this point, subject to further medical examination, is that whatever...
Just a minute, sorry, counsel.
Sorry.
Repeat that, eh?
At what point, Your Honor?
Yes, just repeat that, the right to enforce fundamental rights and freedoms.
And limited to Article 25, sub-article A, and Article 25, sub-article B only. That is express letter of the law. And Your Honor, I was moving into a concession from our end that whatever order this court will make must then allow the second intended accused person to be taken for medical checkup. we have no reason to doubt Counsel Willis Otieno that there are injuries, but that should be determined and medical attention be given upon examination. Whatever order this court finally gives, that is on the basis of Article 25A, because the court has those powers. To that extent, Your Honor, the charges before you are properly before you, before we get to their propriety, the substance of the charges. The DPP, in the exercise of his powers under Article 157, Subarticle 6A, that is 157, Subarticle 6, Subarticle small a, to bring charges and information before you, before this court and the High Court respectively, to institute criminal proceedings against any person before any court. The two suspects are they fall within the definition of any person. Before any court, this court is, except in the case of a court martial, which we are not. So procedurally, the DPP is mandated and was entitled to present these charges before you. That then takes us to the substance of the charges before you. But Your Honor, just before I get to the substance, allow me to address a number of issues which we think are outside your jurisdiction and which, despite your attempts to be courageous and or bold, you cannot get into. That this court cannot enforce constitutional rights and fundamental freedoms outside Article 25A and B. For example, a mention has been made as to the improper or irrational cancellation of a certificate of firearms, contrary to the provisions of Article 47. This court cannot look into that, however bold and courageous. That is outside Article 25A and B. So it means the court must shut its eyes to Article 47. This is not to say that this court is exempt from the provisions of Article 10 of the Constitution on the national values and principles of governance. This court is bound, but from a holistic interpretation of Article 10 vis-a-vis judicial authority under Article 159, vis-a-vis the powers of the DPP under Article 157(6)(a.
Yes, I'm trying to get you and record.
I'm sorry, Your Honor.
Yes.
I have a problem with my
You
tongue.
said the court is bound, is indeed bound by Article 10, but vis-a-vis?
Vis-a-vis judicial authority under Article 159, vis-a-vis the prosecutorial powers of the DPP under Article 157(6)(a, together with Sections 6 and Section 8 of the Magistrates Courts Act, that a holistic interpretation of thereof reminds this court that a number of actions you've been asked to do are within the province of the High Court under Article 165, Sub-Article 3. Sub-Article 3. Your Honor, in other words, the jurisdiction to determine whether an act or omission alleged to have been done under the Constitution is in violation with the Constitution belongs to the High Court and not this court. If the arrest of Honorable Jimmy Wanjigi and or the second accused person violated the Constitution, or rather, whether or not the arrest, whether there were 50 police officers, and we don't take it very lightly, those statements, whether there were 200 police officers, and therefore the action of the police were in violation of the Constitution, that determination can only be done by the High Court, under Article 165, Sub-Article 3. And this is not to say that the police should get scot-free where there are, established violations of the Constitution. And the Constitution has provided for the means to deal with that, including the establishment of the Independent Policing Oversight Authority, with a mandate to investigate such allegations and to punish or recommend for prosecution such police officers. So that, Your Honor, personally, I am very sorry, very sympathetic about the issues raised against the police, and which I have no reason to doubt. But that this court has no jurisdiction to make a determination thereon. And without jurisdiction, you down your pen on that issue. Your Honor, are the police in contempt of the orders of the Honorable Bahati Mwamuye? Again, this court has no jurisdiction to enforce unless the orders are directed to the court to reject charges. The court that issued the orders is the proper court to enforce its strength for violation, if at all, of its orders. Your Honor, if police robbed the family of Honorable Wanjigi, again, this court cannot make that determination. But luckily, Your Honor, as Chief Justice Emeritus Willie Mutunga said, there is no violation of the Constitution that has no remedy. A remedy lies, and it does not mean that if this court, in exercise of jurisdiction, limits its entertaining of the issues raised, that the accused persons or their advocates in that case, who are also violated, will have nowhere to go. They actually have the High Court to go to. And they have gone to the High Court. In a sense, therefore, Your Honor, still on the question of jurisdiction, what is before you is very limited. And that takes me to the substance of the charges. Does this court have power to reject charges brought before it? Yes, we agree easily with the defense. But we disagree on the basis they are inviting you to reject the charges. And from a criminal law perspective, this court can only reject charges in the following cases. Where the particulars of the charge do not or are not in consonance where the evidence is not in consonance with the charges or the particulars, or the particulars are not in consonance with the statement of the charge. You know, that power is granted under Section 89, subsection 5 of the Criminal Procedure Code. 89, subsection 5 of the Criminal Procedure Code, that this court can reject charges on that basis. You can also reject charges where the charges are bad for duplicity, or they are rather duplex. There is no allegation before you that these charges are duplex. So that a charge may not be defective as proposed by the defense for the reason that the actions leading to the charge were in violation of the Constitution. I am awed to be in the presence of very senior counsel this morning. I am comparatively younger in the profession. But I would appreciate if I am shown any authority.
You are relying on the inherent powers of the court.
Thank you for that reminder. Your Honor, this is what
Do I record you in brackets? Senior counsel.
Your Honor, that brings me back to that question of jurisdiction. Allow me to just read a quote from the now retired criminal law guru, Justice Bononga. And this is what he said in respect of what you've been invited to rely on as inherent jurisdiction. I'll quote. I didn't expect this to come up, but I'll provide a copy of this decision. Mm-hmm. The decision is Elijah Nyakebendo Onsongo. Elijah Nyakebendo Nyakebondo. Nyakebondo. Elijah Nyakebondo Onsongo versus Republic, 2017 Kenya Law Reports. And this is what the learned judge said. First, a subordinate magisterial court, which is this court, including a court of senior principal magistrate, only has jurisdiction as may be conferred upon it by any statutory law, including the Constitution. In criminal matters, as in the instant application, such courts do not have inherent powers. It is important to point out that such courts only have inherent powers in civil matters in terms of Section 3A of the Civil Procedure Act. So that another thing as regards to your jurisdiction is that you do not have inherent jurisdiction. Your jurisdiction is given by law only. The Constitution, the Magistrates' Courts